Here. Okay, there we go. All right. So we are at the management agreement. Before we get to this, while we're waiting for people to file in here, now it shows there's 2 people here, but I know there's more. And see, there's some of the documents we went over last time. And you can go look at part 6 to see these. But there were some things I want to go over here just to give a little preface to what we're about to go over here today, in case anyone else is coming in for the first time and kind of have an idea of what we've been covering. And you can go back and look at some of the other episodes we have regarding the express trust. Yeah, one thing you want to know for sure is that we don't advise anything here that's legal, lawful to be used for any kind of personal, private, public purposes, or for any intentions other than the entertainment, educational purposes. For today, I have no legal, lawful knowledge, authority, accounting, or otherwise, so you should not take anything I say here as anything you should take into any kind of action in your real life, and don't do this at home. All right, let's continue. This is a good little thing we're going to say here, and we're not going to go over to the whole thing with everything that we were talking about here. There was a nice little section here with the IRS that we also went over, that being it's that time of year, it would be a good idea to go back. I believe this was covered in part 5, and this is something that you would want to look at too. But we went over this in the other episode. So let's continue now. I want to start with actually the conclusion from the previous parts where we were discussing the actual components of the express trust and how we can affect these instruments here to protect and benefit from. So the conclusion here is the only way to thrive in 21st century America is to own nothing and control everything. And though any trustee is the legal owner of the property in trust, the trustees of express trusts do not experience the incidence of personal ownership due to properly limited liability via trust instrument and the utter shrewdness of the trustees, of course. It is this limited liability that makes the express trust equal to a corporation. But it is the flexibility of choice of whether to function in the common law venue with absolute rights in commerce under the general law merchant, or in the Roman civil law venue with only relative rights in commerce under private international law, that makes the express trust inter alia far superior and unique. Under the aegis of the express trust, the trustee is clothed in a veil impenetrable but from within. This suit of armor is the trust instrument, which molds to the trustee in all his good faith dealings in behalf of the trust, fully compensating him for his services, privileging his use of trust property, and enabling his exercise of creativity in busyness endeavors, all without the excessive weight of inquisitorial legislation. When one is trustee, he is in a fiduciary position, looked upon with respect for the integrity inherent in the position. This has always been the case, except where the power has been abused. Even so, history is clear that there are far more abuses of power via corporations than express trusts. Right. Second here, and looks like we get good stream health going, so we're going to continue. And we got people, it looks like they're filing, and that's good news. We're almost done with this preface here. But this is going to be good to get us juiced up for what we're about to go over. Given the statistics, and the fact that all governments in 21st century America are corporations themselves. Get that? All governments in 21st century America are corporations themselves. It becomes clear that the extensive recognition given to corporations by the state is simply because of the special interest relationship between the two. In a way, it is the same relationship between the John and the prostitute. And it is therefore in the best interest of the prostitute to take measures to keep the John in business in order to indirectly protect her own job security. This is the cause for the general sentiment towards express trust operating in the statutory world. It is this relationship that has bred the irrational view that some trusts have been created independent of statute. Some non-statutory trusts are said to have done harm. Therefore, public policy demands that hereafter all trusts shall be regulated. The irrationality of this line of reasoning will be more apparent if the syllogism is paraphrased thus. Some esquires have been presidents of the United States. Some presidents are said to have done harm. Therefore, public policy demands that hereafter all esquires shall be prohibited. The bottom line is that the express trust relation is the most flexible means to owning nothing and controlling everything, and when utilized shrewdly, affords its participants with all the ingredients to live well naturally. It is also true that no matter how many arguments are made against the express trust, the learned reader will always see through the propaganda and spin, knowing from his own knowledge and independent study that an express trust in reality can only fail due to some misgiving or impropriety on the part of the trustee. The trustee must also trust himself. Okay, so on to the sample forms. And we've already gone through the asset purchase agreement, the assignment, the authorized representative contract, and the authorized representative introduction letter, the authorized representative letter of authorization, the authorized representative limited power of attorney, and I think we are on to the basic management agreement, if I'm not mistaken. Let's see. Yep, here we go. Management agreement. This is where we're going to leave, where we left off, and we're going to continue here. So, again, anyone wants to pipe in the chat and let me know if there's anything where you got any confusion or need any clarification on anything or any words or terms that you're not familiar with. Feel free to interrupt, because if it's you, there's probably someone else that shares that same need, and then I can clarify it for everyone. All right, let's continue. So this is our management agreement, not necessarily a contract, but it is an agreement to have a managing representative of the trust. So this is a human being here, a man or woman, that's going to actually do busyness for the trust, but in the name of the trust. Okay, so this agreement made and entered into this day, month, by and between name of the trust, and you always have to say this, an express trust organization located at address, hereafter referred to as the manager, and name of the trust. An express trust organization located subscribing this agreement at the end hereof, hereafter referred to as the client. Okay, let's continue here. Again, these documents are unfamiliar to me too, so anyone wants to pipe in and help with clarification, it has happened on previous live streams, so it would probably apply here as we read through. If it doesn't start to make sense, I'm sure you'll be able to tell, and then if anyone knows and they can help clarify, please step in. All right, so witnesseth. Whereas the client is in the business of providing particularly described in paragraph 1 below, which business the client wishes to have managed for limited periods of time, and whereas the manager is in the business of providing management services and is willing to provide such services for the client upon the terms and conditions hereinafter set forth. Yep. So this looks like this is different than a managing agent. It's a management agreement. Okay. No footnotes here either yet, right? All right. Okay. So now, therefore, in consideration of the foregoing and in consideration of the covenants hereinafter set forth, it is agreed by and between the manager and the client as follows. Services. The client hereby appoints the manager to be the day-to-day manager with respect to any and all of the aforementioned business, property, or articles listed and more particularly described below. Refer to sample 3 for format of listing particularities. So we're going to have a sample 3 to look at here. 2. Procedure. The client may transfer all titles, interests, deeds, mortgages, leases, or agreements to the manager for a period no longer than 10 years. 90 days prior to the expiration date regarding this agreement, the parties may agree to extend this agreement for another 10 years. This agreement may not be extended more than 3 times. There's your 30 years. So this is interesting here. 3. Duration and termination. 4. Good cause such as death, sale, or disposition of any or all the articles listed in paragraph 1, and any emergency or crises which may affect the financial status of the client. This agreement may be terminated by either party at any time within 60 days prior written notice to the other. In the event written notice of termination is provided, the manager shall make changes only with the consent of the client. Termination of this agreement shall in no way affect or preclude the consummation of any transaction which was initiated prior to such termination. All properties and articles described in paragraph 1 shall be promptly delivered to the client, guardian, heirs, executor, or personal representative after termination, with reasonable delay allowed for recordation of titles, deed, mortgages, or leases. So again, let's see here. The confusing thing to me here is the client wishes to have managed for periods of time and the manager which is in the business. But it's made between the trust organization, that's the manager, and another name of a trust, which is another express trust. Is it the same one? A different one? It was a client. Very confusing. But maybe as we read it, it will start to make sense. So we're going to continue down here. And again, anyone in the chat that might be more familiar with this than I, please pipe in. So we get the, let's see here, powers, acts, and omissions of the manager. In connection with the rendering of services to the client as provided herein, the manager acknowledges with this agreement to undertake the effect transactions on behalf of and at the risk of the client in such a manner as the manager seems advisable with prior notice and approval by the client. So, yeah, this agreement will undertake and effect transactions with risk of the client that the manager deems advisable with prior notice and approval. So there's where the power comes from there. And the managing fees, this is key. The client shall pay the manager a monthly management fee of written amount, numeric amount in parentheses, $1 per month. This fee is payable upon the acceptance of this agreement and payable each month thereafter. All checks must be made payable to, then put their name, state their name. Should this agreement be terminated any time prior to the fee is due date, there shall be no credit allowed for the remaining days, nor shall the client receive a refund. Oh, wow. That's a nice little clause. 6. Further privacy provisions. This agreement and all of the trust business shall be kept protected by the common law privacy rights available in every applicable jurisdiction. The penalty for the release of any information pursuant to the material contained within the context of this agreement or any related material, such person or persons shall be fined or made party of a tort action in the amount of not less than $300,000. Liability. The client in no way relinquishes ownership of his business or properties. The manager may not convert any of the properties held in trust without the client's written consent. The manager may not be held liable for any actions which he may perform in his capacity as manager unless the manager has been found by a court of competent jurisdiction to have acted outside his scope of employment, or that he acted in bad faith in discharging the duties of this agreement. Effective date, assignment, governing law. This agreement shall constitute a binding agreement upon its acceptance by the manager, provided, however, that the client may rescind this agreement without penalty within 5 business days after the execution date set forth below. This agreement may not be assigned by either party without the other party's written consent. This agreement shall constitute a contract entered into and governed by the laws of, name your state, and shall be binding upon the successors and assignees of the parties thereto. This agreement made and executed by the manager and client. This Okay, so witness, client, manager. So interesting thing here that I get, and remember these are sample documents, so there's a lot of this is just kind of left in a weird way. The management agreement being between a trust and a trust. I'm a little confused on that. Client and manager both being trusts, unless it's managed by another trust. So it's one trust managed by another trust. Not too sure what's going on here. All right. Nonetheless, this is why we're going over this stuff, because hopefully maybe Aaron or someone else here knows what this is and can give us a little more clarification. But I do know that we'll have an answer for this sooner or later. If not tonight, it'll be in the comments after this video is out. So here's a bill of sale. It's a very important document here. So bill of sale dated. So John W. Doe, an individual referred to as a seller, sells, bargains, and conveys all of the seller's right, title, and interest. He bargains, I like that. And here's your car, vehicle, to this express trust organization, referred to as buyer. The seller acknowledges receipt of a total of this much money from the buyer in full payment of the purchase price of the goods conveyed hereby. Seller warns that there are no liens or encumbrances on the goods sold, and that seller's title to the goods is clear and merchantable. Seller shall defend buyer from any adverse claims to seller's title to the goods sold. The goods herein are not sold by a merchant in the field. These goods are sold without UCC warranty of any kind, including merchantability and fitness for a particular purpose. Buyer acknowledges examining the goods sold herein. This provision may not be applicable, and legal rights may vary between states. I guess you put this in appropriately. The parties agree to the terms and conditions stated therein. So you get the seller and the buyer being for the trust is an authorized representative in this case, and we do whatever beneficiaries of buyer do hereby. Oh wow! So they get to sign it. The buyer gets to sign it, but it's first notarized by the beneficiaries. Wow. This form can be modified for any transfers of property from trustee to trust, or vice versa, simply by altering the description of the property sold. This document should always be completed in conjunction with purchase agreement in support. Okay, so we have a purchase agreement in support, and then you have a bill of sale. So good tip there. Jot that one down with your Esquire pen if you have it handy, which you should. All right. So that's a great one there, the bill of sale. Ooh, bond. So these are board of trustees in behalf of this trust, an express trust organization, in care of, in this street address near, I love near, so that if you don't put this down, there's no claiming of any territorial jurisdiction for this. Acknowledge the organization's indebtedness to so much money, to this person of address, city, state, county of $750,000. Lawful money of the United States to be paid to these people, his or her legal representatives, successors, or assigns on or before this date with the interest rate of per annum from the state, right? So a yearly percentage rate here, payable at maturity, for which payment I bind myself and my legal representatives and successors. So I'm binding myself. So this is a bond, the trustees, indebtedness, right? So we have caused this agreement to be executed on this date. We have the trustees signed, notarized. So use this form for general bond. As for property purchased on the private credit of the trust. Ooh, a general acknowledgement of indebtedness to a single entity. Wow. So you can have the bond when you're given property or when you're doing a, what they call this here, a private credit. Private credit of the trust. A general acknowledgement of indebtedness to a single entity. So as you can see here, how the trust is working is that all the documents, all the agreements, all the bindings you make are done between the trust and the other parties, and there's no intermeddler of a state in between here. The only time the states jump in or the judicial system jumps in is if there's some type of breach of trust or fiduciary duty. So it's an interesting way to look at this too, is that the trust is where you go through the trouble of going through all these documents and instruments properly rather than having the state do it for you and take full responsibility of that in exchange for them getting control of your assets. Bond. Board of Trustees, in behalf of the trust, an express trust organization, always stating this, for full disclosure. So they know they're dealing with a trust of this place, near this zip code. Acknowledge that the organization is firmly bound to the obligee to this person here, right, with an interest rate of this per annum commencing this date to be paid on this date, which sum represents the aggregate of sums advanced to me by the obligee, as well as drafts, bills, promissory notes drawn to me and paid by the obligee, for which payment we bind the organization, its assignees, firmly to this instrument. So we have caused so. Another one here. This one here is, let's see what they say in the footnote. Use this form for sums advanced to the trust. So this is how we get some advanced sums. And then they'll be bonded to the trust. So that should you not pay back, then the trust, they'll access trust assets. Because you're binding yourself to this. But that's why they're giving money in the first place, right? And here's another one, the Express Trust Organization, principal, and a corporation organized existing under the laws of this, with its principal office located at this address and qualified and authorized to transact a surety business, okay, in this surety, and indebted to, so in the sum of, so here you're dealing with a corporation, right, of surety bonds. So use this form for bond against non-performance of contract. Wow. Wow. For non-performance of contract. And here's your bond. You issue your own bonds. This is great. Your own bonds. Qualified to transact a surety business, and so this is if you have a corporation. That's you would get a go through the whole thing of registering the corporation. Probably get one of your registering agent to do it for the trust, and then you would have that business, this corporation, I'm sorry, organized and existing under the laws of whatever state you're doing the corporation in, so you can do the bonds of surety, right? And let's see here. for the payment of which principal surety binds ourselves, legal representatives, and successors jointly and severally. The condition of the obligation of this bond is that the principal and obligee are parties to a contract, a copy of which is attached, under the provisions of which principal has agreed to set forth contractual obligations of principal. 2. If principal complies in all respects with all terms and conditions of the attached contract and performs all acts by him or her, the person, to be performed under the contract and within the time limit set forth, then his obligation shall be void. Otherwise, it shall remain in full force and effect. And here's a premium. Wow. And each party to the bond has caused to be executed. So this is tremendous. Person will appear before me. So here's your notary. Use this form for bond against non-performance of contract. Here's another bond we got. An express trust organization and a corporation organized under existing laws of principal office located in such and such as qualified to authorize transact a surety business, okay, are indebted to this place obligee for to be paid for. So there's another one where you would have to register that you're doing bonds in your state, right? As a surety, right? To be paid to obligee or obligee's legal representatives, successors, or assigns, for which payment principal and surety do bind ourselves and our legal representatives and successors jointly and severally. The condition of the obligation of this bond is that 1. Principal has agreed in writing to convey the above named obligee good title in fee simple by warranty deed in and 2. Real property situated in such and such county and state. Oh, this is great, man. Okay, so principal has agreed in writing to convey, right? This is your transfer of property voluntarily on both parties to this person, the above named obligee, wherever it is here, the obligee. Good title in fee simple. That means they have full ownership of that title by warranty deed in and to real property, which is not chattel here, situated in such and such county, state, and more particularly described as follows. And here's your legal description from your survey. Subject, however, to the following: set forth all liens, encumbrances, and title defects accepted from warranty of title. Wow. If principal, on or before this date or such later date as obligee may specify, shall execute and deliver to obligee or to obligee's nominee a good and sufficient deed conveying the described real property, accompanied by assurance of title in fee simple, subject only to the liens, encumbrances, and defects set forth above, by title policy issued by title company, wow, or as the case may be, then this obligation shall be null and void. Otherwise, it shall remain in full force and effect. The premium for which this bond is executed is this. Each party to this bond has cause to be executed at this place here. So let's see what they say here. Use this form for a conveyance of real property. You can't speed it up, Jeff. Pay attention. You need to pay attention. That's all. All right. So let's look at this one more time. So we got some elements in here. I know someone was asking today about conveyance of real property through the trust. So here we have an express trust organization, right? And qualified to authorized to transact a surety business, right, in the state. As to city, county, state. Then obligee for such amount of money to be paid to obligee for obligee's legal representative, successors, or assigns for which payment principal and surety due by them. Okay, so obligation, and then we're going to have the contract that's attached. So you use this form for conveyance of real property. We'll probably get to that in another one. We're going to keep going through these bonds. This one here is an express trust organization. Let's see what it is first before I go through it. How's that? Use this form for indemnification of an obligee for a risk involved in a business venture transaction, etc. Okay, so this is like for your own insurance. Yeah, Jeff, that's just like in a classroom. Professor will say, you got to show up on time, or else, you got to catch up later with the notes. All right. So, condition of the obligation of this bond is that if principal shall indemnify obligee's legal representatives, successors, and assigns against any and all loss or damage that may be caused or occasioned by, or that may arise from, and here set forth your risks for which indemnity is given. So whatever you're doing here, it could be, a party, a wedding, whatever, okay? And against all liability whatsoever accruing or resulting from such loss or damage, then this obligation shall be void. Otherwise, it shall remain in full force and effect. I kind of wonder if you can even use this for automobile insurance. But I don't think so. So it looks like for business venture transaction. All right, here we go. Proposal to exchange property. To name of trustees, board of trustees, and express trust from John Q. Public Exchanger. Exchange of brief identification of property for capital interest and organization. Let's see what we got in the footnotes. Nothing. All right, let's see what we could glean from this. Date. Dear Sir or Madam, after considering the benefit of transferring property into your organization, I have decided that an exchange of my property for capital interest holds a promise of attractive future benefits. This offer is, therefore, submitted for your consideration. I hereby propose to exchange the property described below for capital interest. Further, it is understood that such an exchange would be neither a gift nor a sale, but an exchange. If this meets with your approval, please reply. So here's description of property set forth. Existing liens against the property, if any, none. Please respond at your earliest convenience. Thank you. So full disclosure. Good. This is a good sample exchange proposal. Let's look at this again here. This is the trust transferring property into their organization. Right? Oh, wait. To the trust from. Oh, okay. No, they're going to transfer it into the trust. I'm sorry. For capital interest. So, let's continue here. I guess the capital interest is, how does this work? Is it an equitable title to it? Not too sure, but that's something that, again, kind of like a well-prepared dish, the leftovers can be even better than the first helping. That sometimes this is better digested after it's sat there for a while and you go back over it, which is another reason, Jeff, why we keep the class going here, because you got to have it more than once. All right, so here's an application for employer identification number. So now, every now and then, you need to create a corporation to transact in certain kinds of business, depending on what kind of business that the trust has to engage in which case you still don't want to have it giving up your absolute rights. So you do this by applying for the employer identification number with exclusive uses for the trust. So let's see how this is done. This is Form SS4, one we're probably familiar with if we've done any kind of business. Let's see here. Legal name of entity or individual for whom the employer identification number is being requested, and here's our trust name. Executor, trustee, care of name. So here's a trustee. The mailing address. This is the care of. See if we get the footnotes here. See whose address that is. Oh boy. All right, here we go. Let's read some of these things here too. Sole proprietorship or self-employed farmer who establishes a qualified retirement. Oh wow. All right, we haven't even got to footnote 1 yet. These are their footnotes anyways, not ours. Okay, so there's no footnotes for this. Of course not. All right, so we're just kind of getting this blue stuff here is the only parts you need to know that's different from filling this out for most applications to start a corporation or LLC or anything like that in your state. You'll have to do this. So legal name of the entity, training group. This is your trust name here. This is a trustee. This is a mailing address. This may be the mailing address for the trust, or maybe the registering agent's mailing address. Not too sure what's required for this type of thing. Probably it was in the previous chapter, which we'll go back and look at with dealing with the IRS. Here's our city and state and zip code. I take it that's going to be your jurisdiction where you're doing this. So whoever has that address, the registering agent, trust, and name of principal officer, general partner, grantor, owner, or trustor. It's not applicable because we're going through the trustee. All right. Notice that trustee is not listed here. Trustor, not trustee. Okay, so not applicable on this line. And SSN, Social Security number, the employer identification number, or this thing here, no, not applicable. Then when you check on Section 8, the type of entity, you're only check one box, and that's going to be the other. Please specify, and then you're going to actually write in trustworthy. Of course, they wouldn't have that one there, right? They would never put that one there for you. They're going to have stuff like Indian Tribal Government Enterprise and Remake and all these great things here. But they're not going to say this, and they can't stick this one in here. They got two others, nonprofit and profit. So I guess if you had a nonprofit, so there's probably trusts in there, charitable, I don't know. Anyhow, just goes to show why they say the trust is one of those things that's hidden in plain sight or just so well hidden that people don't notice it. Okay, so reason for applying. We're not starting a new business. We're doing it banking purpose. And it's to open a bank account. The only reason we're doing this. And here we go. Third-party designee. Complete this section only if you want to authorize the named individual to receive the entity's EIN and answer questions about the completion of this form. So here's your authorized representative, and here's his, let's see, this is 44567. Is that the same address here? No. So we get a trust address here. So we get that figured out. This is a trust address or the trustee's address, and this down here is the authorized representative address. The designee. That's going to be the designee's phone and fax. It's a good one. And these are both the same as the designee. So there it is. Let's continue down here. Here's the SS4. What is this one here? Oh, they give you a blank one. That's nice. Do I need an EIN? I can read that here. Okay, now we're on to the proposal to lease equipment. Oh, this is nice. To the name of the trustee, to the trust, name of the trust, and this is from, dear trustee, having a need for office equipment and the like, I herein propose to lease office space and list from your trust. To name of trust business. In consideration, I would consider paying an annual lease payment to your trust for an amount agreed upon by written lease agreement. Please respond at your earliest convenience. Trustee, trustee witness, leaseor, and the witness. That is nice. Very simple, isn't it? Okay, cool. Here's your trustee minutes. So minutes are something that we have to take to record the business dealings. Sometimes in the minutes, which should be taken at least once a year, you may have some accounting in there too, but really you should have accounting separate than your minutes. That being said, minutes are still another part of the procedures of keeping order in records that you see in a lot of parliament and other things like that, boardrooms, etc. And it just goes along with the basic, these are well-functioning parts of parliamentary rules. So it's been kind of brought into other elements of busyness and other kinds of transactions that we do. So things like minutes, proceedings for meetings, and rules of order and things like that are there for a purpose. And the purpose is so that there's order and progression when people have to function together. So let's see here. Trustee minutes, successor trustees. At this meeting, the Board of Trustees held in this place and a month. So you want to have the venue and the date. On your minutes, the first item of business is the appointment of successor trustees so here's your agenda items. First item of business is the appointment of successor trustees for this trust organization. The names of persons 1, persons 2 were desired were entered as nominees. Agenda item 2, the Board of Trustees, upon unanimous approval, have agreed that person's name and second person desired are duly appointed as successor trustees and will remain same until their demise, registration, resignation, or removal. 3, it is agreed that the successor trustees will sign the independent contracting agreement and contract with the same terms entered into by the original trustees contained in the minute book of this trust organization. So they'll look back at the other minutes to see the details of this. So they don't need to rewrite it every time or have some mistake. It's a reference to avoid redundancy. 4, all duties in the agreement and contract must be agreed to by the successors trustees. There being no further business to come before this meeting, on motion duly made, seconded, and carried, the meeting is adjourned. So that's how it works. And then they sign it. This format should be used to add successors trustees and can be modified for co-trustees. So you have a record of who's who. So if anyone wants a challenge, if you're the trustee, and it ever came down to that, you have documentation of this in the form of these minutes here. So, and they're signed by the trustees and signed by whoever took the minutes. So this should be the city where the meeting was held. It could be the city where the trustee lives, or you can use a city where the trustee receives mail. Okay, trustee meeting. Corrective action. So corrective actions, we find some kind of nonconformity or problem in performance or delivery or purchase of something. Procedure, etc. So practice or procedure. So we need to correct it. And we want to document this so that we don't see a recurrence of it. At this meeting, the Board of Trustees of Name of Trust held in, so we have our venue again, date. These minutes, while executed this day, are effective as of this day here. Agenda item 1, the first item of business, is the proposal for Name of Trust. So here's our proposal. The Board of Trustees, upon consideration and approval, instruct the trustee to enter the order of the trustees. 3. Agenda item 3. So, or this is, I guess, action item 3 here. The trustee is instructed to place this item onto the inventory of the corpus on Schedule A. List items to be entered onto Schedule A. So it will be listed right here. There being no further business to come before this meeting, on motion, duly made, seconded, and carried, the meeting adjourned. So there it is. John Wayne Doe and John Q. Public Trustees. This format can be used to add or remove assets from the trust corpus, Schedule A. So we could add or remove to place items into or remove from the inventory of the corpus, the body, right? Here, so. Trustee meeting, establishing outside investment funding. This is a good one here. All right. Let's see if we get this thing. We still got good connection going this time. Surprising. I was getting doxed big time last time. Okay. All right. So this is it. Yeah, I don't know, guys, why it's a locked video. My videos are locked. I'm shadow banned. YouTube treats me like a redheaded stepchild, and I'm not even monetized. All right. Trustee meeting. Establish outside investment funding. I like this one. At this meeting, the Board of Trustees, blah, 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 venue. 1. First item of business is the proposed investment of this much money with Native Investment Company for the benefits of this trust organization. The trustees will accept into the trust corpus a whole bunch of money from this person contributing the asset in their personal capacity. The authorized representative is instructed to deposit said funds directly into Native Investment Company on behalf of this trust and enter into the investment the corpus records on Schedule A. Let's see this. Let's see what details. Oh, so this is just purchasing stuff here, right? Native Investment Company. So we're getting we'll accept into the trust corpus a whole bunch of money, and then we're going to take that money and place it into an investment company on behalf of the trust and enter the investment into the corpus. So we've changed the money they've given us. We enter into an investment company. We put on the corpus. See, they're all going in steps here. First item, it's proposed we invest it for the benefit, right, with this company here. And somebody stepped up, said, hey, we'll do our personal capacity. We'll give you that money. So then they say, oh, okay, well then deposit that money into the investment company we decide we're going to invest in. Since we have that money now, thanks to this nice person contributing in their personal capacity on behalf of the trust, and enter the investment now that we put in this investment company into the corpus records on Schedule A. 4. The Board of Trustees, upon consideration and approval, instruct the authorized representative to purchase a new air conditioner with proposed cost, whatever. The authorized representative is directed to place this investment item onto the inventory corpus. So here's what we're buying. Could be gold, could be an air conditioner. Okay. These items were considered and passed unanimously in accordance with original minutes 3, 4, 5, 6, and 7. There being no further business to come before this meeting, on motion duly made, seconded, and carried, the meeting adjourned. So it says here this allows you to compile trust meetings for bulk consideration by trustees. However, if there is only one item being purchased, you'd only include the minute meeting number of that item. Okay, so there it is. Lots of details here. Here's a trust minutes for non-real estate asset. At this meeting, the Board of Trustees, so the first item of business is the proposed acceptance of, list or describe the item, into this trust organization. Cool. Trustees will accept the property into the trust corpus from this person contributing asset in their personal capacity. Why, thank you. 3. The authorized representative is instructed to enter the description into the corpus records on Schedule A and prepare a private property bill of exchange, contract, and agreement, and submit to the trustees for signature. So the authorized representative will make the bill and then submit it to the trustees for signature. There being no further business to come before this meeting, all motion duly made, seconded, and carried. The meeting adjourned. Done. Nice. Okay, if you intend to list a series of items, modify this example so the end of the sentence comes after the list. A sample of the private property bill of exchange contract has also been included in this section. Cool. And here's real estate assets. Now, this is the good one here. At this meeting, the Board of Trustees, on this date, venue, the first order of business is the authorization for acceptance of real property into this trust organization. It is resolved. This is number 2. So second order here, it is resolved and declared by the trustees that the trust organization shall accept a deed for real property made out to the name of the trust for property located in the state of blah. The legal description is as follows. Plot, plat, blah, blah. The deed reflects that the transfer was for $10. Another valuable consideration. Such a deal. It is resolved and declared by the trustees that the organization shall accept a quitclaim deed grantor deed, or warranty deed for the title transfer of said real property and list said property on Schedule A of this organization's contract of indenture. The authorized representative is instructed to file said deed with the local county recorder on behalf of this organization. It was resolved and declared by the trustees that this day's minutes are to be made available for disclosure upon request of any party challenging the authority of the organization to act in this matter. All items were considered and passed unanimously. There be no further business to come before this meeting. On motion duly made, seconded, and carried. The meeting adjourned. So there it is. This is cool. Very simple and recorded in your minutes as the assets are done and the titles transferred, agreed in the trust. All right, so where are we at right now? We're at the we're at that 1 hour mark. How many people we got here? We've dropped off. We're dropping off. All right, we're on a sample 6, the trustee minutes for the authorization for authorized representative to use a trust asset. So we're going to get over, this is a short one. We'll do this one and then we'll move on to the, no, actually this is good. No, we're going to start this next time because we could stick, these are all related to this authorized representative and uses of the trust assets now. So this will set us to a different thing. So today we went over the transfers of assets into the trust. And that's one of the most important things you need to do to get the thing rolling is to get money into that trust or assets into that trust. Now the trust has something to work with. You have some sand in the sandbox to play with, so to speak. Again, the purpose of doing this is to not only have the benefits of flexibility, but also the protections that absolute rights afford. And by understanding the express trust and the way it can be properly constructed, you are not at the mercy of the state doing this for you in exchange for them owning your assets and having control of them to some extent. It's relative. So relative rights, absolute rights, the choice is yours. All it takes is a little bit of learning and unlearning and trust. So with that, I would like to thank everybody for coming in tonight and sharing this live stream with me and learning. We're going to go on to part 8 next time, and we're going to be continuing with these sample forms. Hopefully we'll get some other people to contribute into the chat and give clarification on some of these sample forms as has been done in the previous episodes so I could report back here. We'll go over the form again with any new clarifications that we might get along the way from other contributors. That way, together, we're going to learn a lot more about the express trust under common law. Again, I want to thank you all for spending your time here, and it really is good to know that people are interested in this. You guys being here shows that it is true, and I was just getting stream is going down. That everybody is here shows that it's true that you do have a desire to learn this as I do. And I'll continue with these series on trust. I encourage everyone to go and look at the previous parts I did here. And I also have a multi-part series of trust in American jurisprudence if you want to see some deeper background of trust that go beyond just the express trusts. The express trust is one particular kind of trust that we're working with here just because of the solid legal precedence has been set with them for over such a long period of time. And I've seen just some of the wealthiest and most naturally adapted people that are seemingly that way because they've learned to use the power of the express trust to protect their assets, not for just themselves, but for their family and posterity. Again, I would like to thank everyone for coming, and I hope to see you all on the next one. Please like, subscribe, maybe unsubscribe, resubscribe, hit that notification bell so we can get past the shadow ban. Everyone will get notifications, and we can get a thicker audience in here next time too. But I want to thank you all for coming, and I'll see you all on the next one. Peace out.